Hello, welcome everyone. We will get started promptly at 4 p.m. We'll just give everyone a quick moment to get in. Welcome. We appreciate you being here today. We certainly hope you'll join us for the rest of the series this year. And it is exactly 4 p.m., so we'll get started. Thank you for joining us today. Hello and welcome. My name is Althea Rowe with Center for Applied Linguistics. Thank you for joining us for this 30-minute webinar in our Research to Policy Critical Conversations in Language Education series. This year, our theme is Safeguarding Opportunity for Multilingual Learners in Shifting Policy Context. Today's webinar is titled Upholding the Educational Civil Rights of Multilingual Learners and Families. Today, I am so sorry. We'll be speaking with Megan Hopkins and Allison Balter. I'm joined today by David Johnson Castles, and Deanne Hunter. This event is provided as a public service. The views, thoughts, and opinions expressed belong solely to the guest speakers and do not necessarily represent the views of our organization. Our panel comprises esteemed experts who work at the intersection of research, policy, and practice in language education, language access, and equity. You can learn more about them on our webinar page. We'll place the link in the chat as the webinar goes on. We do encourage you to use the Q&A box throughout the call. If we do have time after the webinar, we'll be certainly able to answer some of those questions. And we'll answer as many as possible. Also, please feel free to chat with each other in the chat box. And with that, I'll hand it over to our facilitators. Thank you for joining us.
All right, I have the first question. Thank you, Megan and Allison. So the first question is, what recent changes at the federal level have implications for the educational civil rights of multilingual learners and their families?
I'm taking that question. Thanks, David. It's great to be here with you all. Before I talk about the changes, I'll talk about 4 key ways the federal government plays a role in multilingual learner education. I'm sure many on this webinar are familiar with these, so I'll be brief. The first is civil rights guardrails. So we know that those are the legal floor for multilingual learner education that are governed by civil rights law and case law, which communicate what schools are required to do so that students identified as English learners, have meaningful access to the curriculum. And it also requires schools to communicate with families in languages that they understand. The second mechanism is through federal education policy, which operationalizes civil rights guardrails through how they're monitored and supported. So under the Elementary and Secondary Education Act, now referred to as ESSA, or the Every Student Succeeds Act, we have accountability systems that make multilingual learners visible in school performance data. And we also have funding, particularly as we know through Title I and Title III, that provides resources to promote programming, staffing, as well as family engagement. So I've said this in other places, but if you think about it simply, accountability and funding often function as the sticks and carrots, where accountability is the pressures to improve outcomes and funding provides resources for that work. So the third way that the federal government supports multilingual learner education is through research and development. So that's through funding research studies, also disseminating evidence and supporting innovation in multilingual learner education. So we've seen that through programs like the Regional Educational Laboratories, or RELs, as well as research grants through the Institute of Education Sciences, as well as federal investments to support the educator preparation and professional development for teachers of multilingual learners, for example, through the National Professional Development Program. So finally, the federal government also plays a role in capacity building, so supporting states and districts as they implement policies and practice. So this not only includes guidance documents and technical assistance, but it also includes national comprehensive centers that provide technical assistance directly to state education agencies. So recent developments have touched several of these areas, if not all. And some of the changes are occurring within educational policy itself, either in the actual policy or mostly in its implementation. But others relate to broader federal actions, and I just want to emphasize this point, such as shifts in immigration enforcement. And these federal changes can also affect how safe and supported multilingual learners and their families feel engaging with schools. Beyond that broader context of immigration enforcement, we see a set of changes that relate to language policy and language access. So we've seen recent executive actions and guidance that shifted the federal framing toward English language acquisition, made English the national language, away from earlier emphases that were beginning to take hold around multilingual access. Longstanding guidance related to language access was revised or rescinded. And while the laws in education did not change, that really affected how states and districts interpreted their expectations around translation, interpretation, and family engagement, and put a lot of folks in an uncertain place in terms of how to move forward in that regard. Another development is in federal guidance on serving English learners. So some previous guidance clarified how schools would comply with civil rights obligations. So we saw that in a Dear Colleague letter that was rescinded. And again, the legal protections remain, but the removal of that guidance reduced clarity for state and local education agencies, and again, created uncertainty. Now, briefly, a couple of other areas. One area to watch in terms of federal changes involves ESSA waivers and accountability flexibility. So some states are putting forward requests to waive certain aspects of federal accountability and requirements and how their funding is distributed, to sort of braid funding systems together or consolidate fundings in ways that raise concerns about whether multilingual learners will continue to be visible within their systems. And then a fourth is related to changes in research and development funding. So some research grants were withdrawn. Some national professional development grants were withdrawn, which drastically affects the teacher pipeline in many states. And at the same time, some initiatives like the RELs and the comprehensive centers, they did resume operations, but they were highly disrupted and created uncertainty and shifts in how states are going to be supported in this area. So overall, I would say the key takeaway is that we know the core civil rights laws protecting multilingual learners haven't changed, but these changes in executive actions and federal guidance and accountability flexibility still shapes how those rights are interpreted and how they're implemented at the state and local levels. And so as we're going to continue talking about, that's why state leadership becomes especially important in ensuring that multilingual learners and their families continue to have meaningful access to educational opportunities.
Thank you so much, Megan. Our next question is going to kind of zoom out, go a little bit more big picture. So if you are dreaming big, what policy changes would you like to see in the future? Where would you like to see that go?
Obviously, I would love to see changes at the federal level to restore some of our emphasis on multilingual learner access, both with respect to multilingual learner education and upholding civil rights, as well as family engagement. But I think the opportunity today is around what states can do. And so what I'll talk about are, I have like a rule of 4 today, 4 ways that states can really think about codifying civil rights protections. So given the uncertainty about expectations for schools and districts, that means that states should really be attempting to codify or clarify protections. So this includes policies that reaffirm core civil rights principles, such as those protections established in Plyler v. Doe, which I know my colleague Allison will be discussing in a bit, that guarantee all children access to public education regardless of their immigration status. But of course, as well as clear expectations around language access and program quality. So some strong and clear protections for multilingual learners' civil rights. But then also, states could align funding and accountability systems more explicitly to support multilingual learners. So we would have funding and accountability systems, state funding formulas and accountability systems that clearly signal that multilingual learner success is a priority through both how progress is measured and how resources are distributed. So on the funding side, state funding formulas for multilingual learners, if they exist at all, tend to vary widely and often might not reflect the resources needed for high quality programming or how those resources might differ across different kinds of populations and contexts. So from very small populations to very large populations, or very diverse populations to less linguistically diverse populations. And then on the accountability side, policy decisions really determine, as I said, how visible multilingual learners are in school performance systems. So as states consider ESSA waivers, one thing I would hope to see is that those decisions continue to maintain strong visibility for multilingual learners. And then third and fourth really related to building coherent pathways to bilingualism and biliteracy. So in some states, like Massachusetts, which we'll hear from later, we've seen significant growth in initiatives like dual language education and the seal of biliteracy. But in a lot of places, those initiatives operate separately and often tend to privilege English proficient students. So another policy direction would be supporting coherent K-12 pathways where students have access to bilingual education early and then culminate in the recognition of seal of biliteracy in high school. And then fourth would be to support these efforts, investing in the multilingual educator workforce. So many states, I'm sure I'm preaching to the choir here, are facing significant shortages of teachers prepared to work with multilingual learners, especially bilingual teachers who are important in both bilingual programs and other programs. So another major policy priority would be stronger investments in the bilingual teacher pipeline, including things like grow your own programs, university partnerships, and policies to support recruitment and retention of educators. So overall, I'd say that the goal would be that state education systems recognize multilingualism as an asset, protect the civil rights of multilingual learners and their families, and work to align their policy, funding, accountability, and workforce investments to support that vision. I was dreaming big.
Good job. Thank you, Megan. Our next question is, what policies have been put into place in your context, or others that you're aware of, to uphold multilingual learner civil rights?
Great, thank you. I'll take this one. It's great to be here with all of you today. I am the director of the Office of Language Acquisition at the Massachusetts Department of Elementary and Secondary Education, and I'm excited to share with you some of the things we've learned in Massachusetts. And one of our big lessons, as Megan was sharing, is that while federal law establishes civil rights protections for multilingual learners, states really play a critical role in translating those protections into durable policies and systems. And so in Massachusetts, in recent years, we've taken several steps to codify protections for multilingual learners as well as their families into state law and policy. And I'll share a few examples of these. The first is a law called the Look Act, which expanded access to high quality multilingual programming. The second is a recent law called the Protect Education Equity Act, which reinforces educational access and non-discrimination protections for multilingual learners and their families. And then thirdly, I'll talk about, in addition to legislation like these two examples, ways that we have leveraged ongoing cross-agency partnerships and executive actions through our state government to ensure that schools remain safe and accessible for immigrant families. So altogether, these efforts reflect, I think, a broader commitment and a strategy across our state to embed civil rights protections into the structure of our education system in a proactive way. So I'm going to walk through each of these examples, but one underlying point I want to emphasize is the key role that advocacy organizations and partners across the state have played in making some of these significant legislative and policy changes, and the importance for all of us in strengthening our collaboration and relationships across, functions, across organizations in the educational ecosystem to move things forward. So let me talk first about the Look Act, which is a piece of legislation that was passed in Massachusetts in 2017. And this was a major shift for us in how our state supports multilingual learners, specifically through programming for our students. And the law explicitly addressed several barriers that had previously limited educational opportunities for English learners in our state. It was notably championed by a coalition of organizations, different advocacy groups across the state that called themselves the Language Opportunity Coalition. So included our Massachusetts TESOL affiliate, MATSOL, the Multi-State Association for Bilingual Education Northeast, or MABE, and the Massachusetts Foreign Language Association, or MAFLA. And these organizations came together because in Massachusetts, Since 2002, prior to this legislation, we had been an English-only state as a result of a ballot initiative that passed. And so the only programs that our English learners had access to essentially were sheltered English immersion programs. And so when the Look Act was passed, it removed those restrictions and expanded the ability of districts to implement bilingual and dual language programs, like Megan was referring to earlier. And this really matters from a civil rights perspective because it ensures that our state law is providing for our multilingual learners to have access to programs that both support their English development and sustain their home languages, and reframes bilingual education not as an exception, but as a viable and supported educational pathway. And so the Look Act accomplished this as well by strengthening program quality and accountability. And so it wasn't just a matter of, great, we can open up a whole bunch of new programs, but it strengthened expectations around the quality of these language programs. And so that included stronger oversight on the part of the State Department in terms of our multilingual learner programs. It meant that as districts decided to open new programs, they actually had to apply for these programs, develop proposals that had to be approved by the state before they implemented them. It established clearer expectations around educator qualifications, and sort of thinking about that pipeline that Megan was talking about to staff these programs. It also required monitoring of student progress in their English language development, regardless of program that they are in. So these provisions from the Look Act really helped to ensure that multilingual learners are not just placed in programs, but are placed in programs that are effective and accountable for results. And then the sort of third and I think final focus area of the Look Act is the idea of promoting multilingualism as an asset, right? This law really shifted the narrative for us around multilingualism in our state, moving us from an English-only place to positioning multilingualism as an asset to be developed through our bilingual education programs that we're building and growing now, and through biliteracy pathways and establishing the state seal of biliteracy as a way to honor that for our graduates. So ultimately, right, this shift reflects, I think, a really important civil rights principle that students should not be limited by their linguistic background, and that is part of our state law and part of the work that my office does on behalf of our multilingual learners. So that was an important policy shift that happened, right, several years ago now. Fast forward to today, right, we're in this complex climate now. And so now I'm going to talk about a very recent law that was passed this August 2025, and it's called the Protect Education Equity Act. And so this is also something that is now embedded into our state education law, and it further strengthens protections for students and families. And it does that by codifying several federal civil rights protections into our state law. So Megan mentioned earlier Plyler versus Doe as the case law, right, that protects the right of all students to attend public schools regardless of immigration or citizenship status. So what the Protect Education Equity Act does is now codifies Plyler versus Doe into our state law. So now citizenship status or immigration status is a protected class in Massachusetts for students. And so if that were to ever go away at the federal level, it would still be protection within our state law. The second thing that this new law does is it expands or improves language access for families. And so, we have had, right, we've had the requirement to provide translation and interpretation for families in our schools. That's not new. But what this law does is requires our state to establish standards for qualified school translators and interpreters. And so that really helps us ensure that families can meaningfully participate in their children's education, because we know that family engagement is a core civil rights issue. And then finally, this law also embeds some protections for multilingual learners with disabilities, which has been a really important piece. And so it strengthens some procedural protections for English learners with disabilities, ensuring that they get appropriate services and safeguards, including, having someone who has expertise in second language acquisition be a part of the IEP team, for example. So that's something that is now part of our state law. And we're in the process of, this is very new, we're in the process of promulgating regulations and implementing these new pieces of our law. And so the last thing that I'll just touch on, right, is obviously legislation is one piece of the puzzle, but it is only one piece of the puzzle. And I want to emphasize how Massachusetts has also worked to coordinate collaboration and support across our state government agencies, as well as just within our state Department of Education, to ensure that schools remain safe and accessible environments for immigrant families. One example that I can give just right off the bat is our executive level, right? Our Governor Healy, has been at the forefront of a lot of this conversation, and she has taken very proactive action to reinforce that schools should remain safe spaces for families. She signed executive orders and filed legislation herself to, include policies that limit immigration enforcement activity in sensitive locations such as schools or other, public properties. And so that leadership has been really important in supporting this work. But even outside of that, we have worked hard to coordinate partnerships and relationships between our Attorney General's office, again, our State Department of Education, our State Office for Refugees and Immigrants, to put out guidance that is co-developed and co-sponsored, to lead webinars for schools and district leaders, and really, ensure that we're all kind of rowing in the same direction. And even internally within our Department of Education, we have had cross-office collaboration. Folks from my office that works on language acquisition, folks from our commissioner's office, our college and career readiness office, our student and family engagement office. We've been coming together regularly, even over the past couple of years, to talk about how we can better meet the needs, the multifaceted needs of our newcomer and immigrant students. And one of the things that I think has led to this strong collaboration is that it didn't just start right now. It didn't just start in the face of some of these, federal changes. We've been doing this together for a while. A couple of years ago, we saw in Massachusetts a pretty significant surge of new immigrant families coming in through our emergency shelter system, and came together to say, what can we do to better meet the needs of these students and families and the districts and schools that serve them? And so we had been already activated for that purpose. And then as the federal climate changed, as the challenges shifted, we already had these coalitions and these collaborations ready to go and pivot in order to meet the needs that we were seeing. And so, I think just to summarize, there are ways that we have leveraged legislation to implement protections of civil rights for English learners and their families, and to strengthen and improve programming for students and families in schools. And then also ways that we've leveraged these kind of policy collaboration to really prioritize this work across our state government.
Thank you so much, Allison. We really appreciate you sharing all of that information. So our last question, I started very big picture, pie in the sky a little bit. I'm going to bring us down to earth a little bit now and think about what steps would you recommend that educators, leaders take on to support policy change, like thinking very tangible things people can do right now.
Yeah, I can jump in here and then kick it to Megan as well. I think I've touched on these just in the examples that I shared, but just to sort of summarize, I think there's 3 lessons that I would elevate from our Massachusetts experience and recommend. The first one is just understanding that states can codify federal protections. The state policy and law doesn't have to exist as sort of a silo or a parallel to federal law, but there are ways that we can leverage it to, again, see federal law as the foundation and see how states can really sustain and strengthen these protections. And we may not have direct influence over those state laws through whatever our positions are, but I think this is where it is important to, as I mentioned earlier, build strong coalitions across advocacy organizations, across school and district leaders, educators, right? All of the folks who are in this ecosystem of supporting our students and families. Each of us can play a different role. And so making sure we have those connections and strong relationships so that, the people who can advocate with our legislators can be present in doing that. But we're, again, sort of all rowing in the same direction in terms of what outcomes we want. And then, I think the last thing that I'll emphasize, and Megan touched on this earlier, is just the importance of seeing the connection between civil rights protections and program design. And sometimes we see these things as distinct, right? We see like the program design as this is, the sort of instructional work we do, designing like, teaching and learning, and that's a huge part of it, right? But program design itself can be a civil rights issue and can be a way of codifying and upholding and supporting our students and families' rights. And we know that when multilingual learners have access to high quality bilingual programs, biliteracy pathways, access to rigorous coursework, they're better positioned to succeed academically. And so thinking about, for those of us who work more closely to the program side or the instructional side, how we can leverage that aspect of the work as well. What would you add, Megan?
Yeah, two of the main points I was going to make was around building coalitions. And then, as you said, really connecting policy or civil rights law to implementation. I guess I would elevate one more thing, and that's around making issues visible through data and evidence. So one of the most powerful tools that I've seen leaders use is making multilingual learner experiences and outcomes visible. So looking carefully at their data on things like English language proficiency growth, access to high quality programs, teacher certification, teacher qualifications. So when you bring those data into policy conversations, it really helps shift the discussion from abstract or ideas or things that might be viewed as ideological to concrete needs and opportunities for improvement. So in a lot of cases, policy change really begins by simply helping people see the issue clearly. And in that way, also engaging families and communities as partners to really hear about what's happening on the ground and have that informing decision-making processes, which is part of that coalition building that Allison discussed. One thing I want to highlight about the policy change, at least regarding the Look Act in Massachusetts, is that the Look Act revised education legislation and code within the English Learner Code. Whereas in other states that have broad dual language mandates are just general laws for all students. And so what Massachusetts did by specifically altering those policies for English learners was to ensure that English learners are served in those programs, rather than being sort of co-opted or taken over by students, English-speaking students who are learning another language. So also being purposeful about where those changes are made and who they foreground can be really important. And using data and evidence again and elevating the voices of the community can really help to demonstrate the need to do that.
Thank you so much, both Megan and Allison. David, did you
there was a question I saw about if these Massachusetts laws came with funding attached that I thought that Allison might want to address.
Yeah, that's a great question. I was just looking at that as well. So yes and no. These new laws, so specifically the Look Act, I guess, right, that was developing our new program opportunities and models, did not come with new funding in terms of like, additional per pupil funding or things like that. But what it did come with was a new line item in our state budget around English learner education programming that our office has leveraged to put out grants to districts in our state. And so we have a couple of different grants that we put out each year. One of them really focuses on schools and districts that want to start or launch bilingual programs and need some seed money and building teacher pipelines and things like that. Another one focuses on strengthening our Seal of Biliteracy program, purchasing the assessments and things that districts need to implement the Seal of Biliteracy. So we've leveraged those grants. They're not huge grants, but they're grants that we have prioritized to help implement and spread this work and these new types of multilingual programming.
Well, it looks like we've run out of time. We do thank our presenters for being here today. We're so grateful that you took the time to share your insights. Thank you so much for being here today. Thank you to everyone that's here that registered. We're very thankful that you joined us. A big thank you to our facilitators, David and Deanne. Thank you so much. We hope we'll see you at the next webinar next month. Please watch your inbox. We'll be sending a follow-up email along with the recording of this webinar and a one-page resource. Additionally, in the chat box, you'll see a link to the webpage for this webinar. Thank you, and we hope you enjoy the rest of your day.